Why did you get in that bag? We drink a little wine, no one knows us. He said, Sarah. Sarah. That's my name, don't wear it out. It's not intentional.
Sarah
to
Boone
fall
needed a
asleep,
lawyer.
I swear.
Not malicious.
I fell asleep.
Not malicious.
Then I fell asleep. I fell asleep.
Because it makes it sound like to me, like I'm being accused of something that was not intentional. I'm being accused of it.
Not intentional, no.
Right where it is.
Right down there.
Yes.
You did forgot he was in the bag of dead and stuff. Not intentional.
And I can't imagine a system
It will all make sense when she takes the stand. Oh, Sarah, Sarah.
Now you all think that I had even more input intent to do what I did, which was not intentional.
He said, Sarah, Sarah, Sarah. That's my name, don't wear it out. It's not intentional to fall asleep, I swear. But he said, Sarah. But he said, Sarah. We said, Sarah. Sarah. Sarah.
Hello everybody! Excited utterance here. My name is Hella. This is Seraph, and he's decided he's in a bit of a bad mood. Aren't you? You in a bad mood? You gonna bite me? No. Come on. You were happy a minute ago. Meow, meow, meow. Oh well, these things happen. Okay, calm down, alright? Jeez, such a grumpy old man. He's 18. 18 years old this year. Yeah, and he does get the grumps, don't you? You get the grumps? Oh, I see. That makes things better. That makes things better. Yeah. He's like, I'll put up with this for about 20 more seconds. Yeah. But generally he's fine. Generally he'll like hang out for hours. But once he decides that's it. And meh, gone. Hello, everybody. Oh, it's like Sarah when she hasn't had her snacks. Okay. No arguments. Fine. You go up there then. You go up there. That's all right. We can see you. Okay, bye. All right, he's gone to behind the monitors. Hello, everybody. Hello. Look, I even got a new lemon for today to make lemonade, but I think the motions in lemonade are over. Maybe. Pretty sure. I think they've seated a jury. Finally, look what I called today's stream. Today's stream is called, Oh My God, Please Let This Thing Start, plus games. Yeah. Seraph loves, like, okay, here's the thing, Scott. Seraph follows me around everywhere. He won't sleep anywhere except, like, on my head. This cat is so needy. And then he goes and does that. It's like he's a princess. When you are like 90 in cat years, you can do whatever you want. Okay. All right. So guys, stuff that's happened today. I actually stayed up really, really late, like 1 a.m., which is, I don't know what, 10 a.m., 11 a.m., something like that, court time, and watched what happened in the motion hearings this morning, your time, and saw that there was a little bit of argy-bargy in the courtroom regarding the evidence that's been submitted. So we're going to watch a bit of that. Yay, fun, always like a little bit of drama. And then jury selection continued. It was pretty boring from what I saw. Not going to watch that really. But it does seem that a jury has been seated, and it looks like there's going to be opening statements tomorrow morning. Thank God. Thank God for that. I really thought that this was going to go on for another couple of days. Oh, KLF, hi, Hella. Richard Allen's team is allowed to bring in Odinism now. What? okay, like all these things are happening at once today. Okay, so we have a jury for Sarah Boone, and Onism was allowed to come in the Richard Allen case. The sky is falling, everybody. The sky is falling. That's incredible. And by the way, I made a video about whether or not Judge Gull is actually a human being. Go and have a look at that, guys, when you have a chance. I got permission from Andrea. She quite likes it, so I hope she likes it, because she said it was okay to post it, so... yes. Cool. All right, let's get into it. Oh, hello, Obscure. Good to see you. I said it before and I'll say it again. I could fix Sarah. Oh, yes. Oh, hello there, Kathy. Hi, hello. Hope all is well in chat. Nice to see you. Good to see you. And oh my God, John. Happy birthday, John. John is turning 33. 3 and 3. I hope those are 2 lucky numbers for you. Happy birthday, John. Thank you so much for the 5 Excited Utterance memberships. Everybody say happy birthday to John. Come on, let's embarrass him. Thank you so much. Happy birthday to you. You are a wonderful mod. You're a wonderful person. Also, thank you for your service. You are in the military and you do a wonderful job. We just love you, John. You're part of the family. Happy birthday and thank you for the memberships. That means that we are 5 more into our next milestone. The last one was the dancing dog up there. Now, I have had a request from Half Irish that the next thing that we put into the apartment is some Pop-Tarts, because apparently Sarah Boone really likes Pop-Tarts. So unless anyone has any better ideas, I'm up for the Pop-Tarts. I think that's a good idea. We don't really have them here. That's an American thing. Apparently she likes Pop-Tarts. So, well done. Cool. So yeah, 5 into it. We need 20 more gifted memberships or memberships to make it to our next thing in the apartment. The sky is falling. Hella, October 17, 2024. Why, thank you. All right, let's get into it, guys. Happy birthday, John. Happy birthday. You love Pop-Tarts? They're very sweet, aren't they? I'm not really into like the whole like sweet. It's a breakfast thing, isn't it? Like to have like sweets for breakfast? No. Nice seeing you in the Trial TV jury stream. I don't really fit in there. I make lots of comments about Sarah looking pretty and stuff like that. They don't tend to like that over there, but you know, whatever. Each to their own. They're sugar bombs. Yeah. Alrighty. Let's get into it, guys. So this was the beginning of the motions this morning. Now, I'll warn you in advance, the defense team didn't seem to know where their microphones were, or their microphones weren't working. However, the captions worked. So I'm not going to try and adjust audio because it will mean that all the other audio is far too loud. Now, Trial TV had by far the best audio. Apparently, Recovery Addict is in some way involved in this transmission, and he adjusted the audio for the defense somehow, made it a bit louder. So that's good. But we are going to have to do a little bit of lip reading and read the captions for when the defense is talking, unfortunately. So, but it's worth it. It's an interesting set of motions. So let's have a bit of a listen and also observe how pretty Sarah looks today. Let's go. Now, audio's coming in. Just wait. Also, how pretty... Oh, she wants a pen. How pretty are James Owen's team members? Like, he's got, like, Shelby. And who's that other lady? She's pretty too. Hey, Emu. How are you? I've had an MRE with generic Pop-Tarts. Was good. Oh, what's an MRE? Hey, Robin Hood, good to see you here. Sugars for breakfast. Okay, starting to get audio coming in now. Hang on. What's going on? Bring it in. Okay, it's just going to come in. I'll tell you when I can start to hear it, and then we'll adjust it. No, there we go. Very low yet.
Ms. Boone is seated at counsel's table wearing a dark gray suit and a yellow blouse. She is in custody, however, she
Give it a
is
sec.
not being shackled for the purposes of the trial based on the court's prior findings.
Oh, there we are.
We're here to conclude the objections as identified in the state's
military
response
food.
to defendant's Fifth Amended Reciprocal Discovery Exhibit List. The court has reviewed the objections and the defendant's Fifth Amended Reciprocal Discovery Exhibit List. Anything else we need to address, State, before we begin addressing those objections?
How's audio,
Last
guys?
written order from yesterday's rulings on the court's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am
Thanks.
not in violation of any motions in limine or any case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating you to type a written.
Okay, that's what I wanted clarification on.
Okay,
Thank you.
because judge is really loud.
I do want crystal clear clarification as to what we are both doing. Because based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment.
So you're not allowed to approach the clerk with an exclamation mark. And she also didn't do a job yesterday, apparently.
You did not.
You did not. You did not.
Madam Clerk is advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that.
Thank you.
Madam Court Reporter, how long do you think that would take you? Is that acceptable? Can we address it at 1:30 before we come?
How does this happen?
Prepare for opening statements and I don't know what I can say.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box, but
Submarine.
I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable?
No.
Okay, well then, short of taking a break right now and having her create it, I don't know what else to tell you.
Can we finish jury selection? Mr. Henderson is going to take it this afternoon. I guess we start at 10:30 or 11, and that's going to spill into probably late afternoon before we actually turn 5th. And we just agree on Friday.
Oh, sorry, I'll take this away so you can... Oh, the captions didn't even get this.
State?
God.
We have an out-of-state witness and people that are scheduled to come in, so we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning.
All right, I'm going to fix this so you can
Mr. Henderson, how
see
much time do you think you're going to need, sir?
this a bit better.
Okay. R- Correct. That's correct. Okay. Mr. J?
I just need that ruling so that with enough time to prepare.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Clerk, Madam Court Reporter can provide a rough draft of what was ordered yesterday, and we could go over it and review it, and make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions in limine. Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed. I understand
so
your
amenable.
concerns of running afoul with the motion in limine. I totally understand that. But
Hey,
it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening
No,
statements.
I
and
love you
use every waking
too.
moment we have to not waste these jurors' times until 5 o'clock today.
Okay, all right. Madam Court Reporter, how long do you think it would take you? Is that acceptable as opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now? Sure. Okay, all right, then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State, or Mr. Owens?
that's pretty good work, 20
10,
minutes.
15, 20? Okay, great. All right, we'll be in recess till 9:45. Thank you. Yes, sir. Yes, sir. Yes. You're talking
Why,
about the
Scott?
motion in limine regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine.
Oh, come
Okay,
on.
well, that
captions.
saves me some time then, so I appreciate that. All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial? All right, motion's granted. All right, we'll be in a brief recess till 9:45. We're off the record. Thank you.
All right, so let's fast forward. Okay, so what Scott told me during my night was that 20 minutes that we're about to go through here is when, well, he clarified for me, is, hang on a minute, why is 20 minutes not passing? Is when that all got fixed up. So the issue with the minutes and the records not being ready got fixed up in that 20 minutes rather than them having to come back at 1:30 p.m. Now, hang on a minute. Why are they not in recess? Oh, they are in recess? That was a quick 20 minutes. Hey, Dolly.
Okay, Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Ms. Boone, a third of your defense team is not present at the moment. Are you amenable to proceeding without Mr. Beck being here? Okay, thank you very much. Oh, that cures itself. Counselor?
Should have said no.
Thank you. Record reflect that Mr. Beck has just entered the courtroom. All right, the court's had the opportunity to review the excerpts from the motion in limine hearing from yesterday, and my understanding is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate?
Hey.
Okay. The court's reviewed it. Are there any questions with regards to the court's rulings on that motion?
Yes, Your Honor.
Yes, sir.
My understanding is that based on
Sure. Madam Clerk's providing you a printed copy, sir.
Don't approach.
Bless you.
Don't approach. Get away from her.
Have you had the opportunity to review that excerpt yet, Mr. Owens? All right, go ahead and take a look at it.
Hang on, that's 3 exclamation marks, Brad. There should be only one. No. Hang on, where is Beck? I haven't seen Beck.
Who?
Beck. So there's 3 lawyers. So there's Henderson and Owens. Where's Beck? Yeah, right. I can count lawyers. I'm one of the very few YouTubers who can count lawyers. Oh, look. Is that Billy Lane in the back there?
Yeah.
It's Sarah's crush.
Yeah.
Oh, he sits way in the back. But that's, hang on, is that Billy in the back there? That's not Beck, right? That's Billy.
That's Billy.
Yeah.
Okay.
Billy.
All right, Mr. J, you may proceed.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from, there were several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion, though, but paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916, Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005. which
Can you
was
pause
quoted,
it?
Quintana, Quintana versus.
Real quick, is that Urkel in the background?
It's a woman. I'm pretty sure that's a woman.
I'm pretty sure that's Urkel. I didn't know he became a bailiff. Oh, good for him.
Maybe that's what he grew up to be. Maybe he transitioned as well.
I
don't know.
I spent like 15 seconds confirming that reference, hoping the state honor, and I got it in there.
Okay, right. Good pickup.
State,
I never even watched the
452,
show.
Southern 2nd, 98, page 100, a Florida first DCA case from 1984, also quoting Williams versus State,
Hey,
252,
David.
Southern
Come on.
2nd, 243, 246 is the page, Florida fourth DCA, 1971, Reed, REID versus
Is
State.
Mr. J the
213,
most
Southern
boring
3rd,
person in the world?
1110.
Oh,
page
did you hear him do the
1111,
rap?
Florida
Who?
fifth DCA.
Are we gonna? Is this before when he reads into the record the lyrics, or not the words of Sarah on that videotape?
No.
Oh yeah, it's like spoken rap. Like if you drop a beat behind it, it sounds real good.
Oh, sweet. I might have a beat.
Do you? Because the one I did wasn't really good.
I could do a beatbox.
I don't know if it's gonna come up yet. This is from the morning, right?
Yeah.
Okay, then it will.
Okay, sweet.
2017. Rudin versus State, 182, Southern 3rd, 724 at page 726, Florida First DCA 2015. So what we were asking for is in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled the battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Thank you. Response.
I just have one question as to what time. Are we talking about for dire? Are we talking about?
For God's sake,
At what time?
talking to the microphone.
During the testimony in the trial.
That was my takeaway.
Okay, he's absolutely correct.
Okay, the motion's granted. So the court's going to rely on that specific excerpt in Holland.
gave that up pretty quick.
9:16, 7 seconds, 750. At pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on particular occasions, section 90.4041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be.
Okay, Robin Hood, I can totally tell you why people like the prosecutor. It's the same reason why people like the judge. It's because everybody hates Sarah, right? And I tell you something, today I've been noticing people bringing up again bullshit about Mr. Owens and Mr. Henderson and their past, right? Crap from like the 1990s and stuff that, like, okay, there was a SA allegation against Mr. Henderson, right? From the
And
1990s.
Owens, right? Or was it Henderson?
Owens was there, right?
Okay, so they were, okay.
That was like they're mates. They've been mates
Yeah.
for 30 years, right? So it was an allegation. It was not ever proven. Nothing ever came of it.
It was really, the way it was, like, it just didn't sound credible.
Okay.
In
So
my
it doesn't exactly. Well, I mean, who knows? But it never came to anything, and it was in the 90s, right? So people are pulling up this shit and trying to slander, because I mean, it really, when it comes down to it, if there's no truth to something, then that is, in my limited understanding of what slander is, slandering somebody. Like, people throw the word slander around, but when you are speaking badly of somebody and you are saying things about them that have no truth to them because they've never been proven, and that is then impeding or giving them a bad reputation, which is impeding their work, then that's slander, isn't it?
I believe libel, if you're writing it.
Writing, but people saying it on YouTube as well.
That would be slander.
Yes, absolutely. And the only reason they're doing it is because they hate Sarah, and they don't like the fact that these people have come at the 11th hour to help Sarah. And they just think that it is, that they're doing it for some sort of gain, and it must be some sort of evil intent. Whereas defense attorneys aren't terrible people. They're not. They're guilty of libel, blood libel.
I mean, the worst they're guilty of is being a lawyer. So, I mean, yeah, they are terrible people, but not because they're criminal defense attorneys.
Yeah, I mean, why bring these things up? And also, yes, in answer to your question, the prosecutor isn't automatically a great person just because they're prosecuting Sarah. This guy has been, this guy is being extremely passive aggressive. He's included a lot of very negative terminology in his motions, and I mean, Kranik is no angel either. Like, he, in my opinion, he has completely brought on this situation himself with all of these things that are occurring at the 11th hour, with defense coming along with these large documents that the state is saying, oh, we are stuck with all this 500-page document, this 200-page document. Well, what do you expect to have happened when you haven't allowed a professional team of lawyers to do their job? Like, they've come in and they've had only like 3-4 weeks. Of course they're going to dig up information. And you've given them no time. Well, that's what's going to happen.
Yeah, they're not going to be able to be prepared, and, well, they're going to be doing the work behind the scenes. They're not going to be as prepared, though, for motion hearings in court. So, like, if you ask them these questions, like, oh, can you get me this information? They're not going to have it offhand because they're not done unraveling their whole plan. Yeah. So they're coming up with stuff on the spot.
Absolutely. Thank you, David. Yes, I like these defense attorneys, and I'm shouting it in every YouTube chat out there. Absolutely. I think Henderson doesn't have a good presence in the courtroom.
No.
And
Okay. I will. Yeah.
Yeah, I think he should take a back seat. But that said, all this stuff about the discovery coming up at the last minute, what does the court expect? Of
Yeah.
course, the discovery is going to come up at the last minute. The court has brought this on itself. There should have been a continuance, and he was just being pig-headed about it. Sorry, like that is silly.
And God had to make a damn hurricane to get 1 week.
Yeah, exactly. Let's keep going.
Be granted.
Judge, and, just understand, put on the record. It's just procedurally, before we put evidence up,
Can't hear a damn thing, just about.
in this case, we don't have to ask for it.
Received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that beg of
Hey,
the clerk of the
Brandon.
court, and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday, at some point, for the record, for the 6 DCA.
Okay.
Yes, ma'am.
All right. Thank you. Anything further from the state before we proceed with the objections? Defense.
Judge, yes, just my overall understanding is that the motions and the orders that the court has applied to trial and the organization will flow of the evidence at trial. Certain things have to be presented before certain witnesses can testify. It has nothing to do with court diet.
That is correct, and the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right, thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today. Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the
Yep,
opportunity
let's get
to
on with
review
it.
that fifth amended reciprocal discovery exhibit list filed by the defense, I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to provide as the ones that you have objections for, and I have notes with regard to all of them, so you may proceed, sir.
One by one, I assume?
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera, so we can ping pong it back and forth from there.
All right, regarding item number 1 on the fifth amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Response from the defense.
You're referring to 1A1?
We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is States 2 was 81 pages of records regarding treatment by...
I'm not talking about 2. You don't object to 2. Talk about 3?
Well, I do need to talk about 2 now because
Okay.
This morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I
what's
got
that?
them all formatted. I was able to read them while we were waiting for Madam Court Reporter.
Sorry.
They do not appear to be completely the same as what has been previously provided by the
Thought my
defendant in
mic was
regards
off,
to
and then I
Winter
went to hit
Park's
my
Advent
mic,
Health
turned it
treatment
on,
fees.
and then
So I just want to
Hang on. Okay, we'll just go back a few.
Sorry.
It's all right. Dali's playing Candy Crush.
No, I was working on a meme.
Oh, really?
Yes.
Okay.
Yeah, the whole rap
Don't
thing.
give too much away.
A digital picture.
Stop
They were upside
calling
down,
me
they were
David.
sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Ms. Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Referring to our paragraph 2.
Oh my God.
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27th, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time.
Not a Richardson hearing.
Ready, 81 pages are not at issue.
I understand, they were given Sarah from the Advent Health report. The 119 pages, my understanding, we thought we previously, we realized yesterday, last, that we had not sent them, so we provided those to you today as soon as we were aware.
Hello, Owens.
And
Something
what
you'd
do
like
the
to share with
119
class?
pages evidence?
They're medical records from relating to Sarah Boone over a period of time, so that's going to be whittled down, depending on her testimony, whether or not it will cooperate.
Should have stayed retired.
Injury, hands of one story.
Asshole.
Shut up.
I need more specifics than that. I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured, which would coincide with the
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter.
Yeah, it does sound like it's a scam, right? It's like, let's have a Harold hearing. they're at the back having a Harold hearing, and they're just like talking like this. Oh dear.
Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things? Moreover, I need to make a determination as to whether this
Oh, now what?
violates the
Oh,
three
they had
problems that I
issues.
need to address.
Yeah.
One sec, Hella.
You're right.
My understanding is the first
Thank you.
81 pages were medical records of Sarah Boone that we got from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week, and we just failed to immediately provide those.
When did you receive them last week?
I'm not sure, Judge. I think it's Secretary, we have to break and let me find out from the Secretary when we receive it.
Okay. I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what.
My staff is
Understood.
texting her.
All right. Well, I'll make a note to circle back to this issue. Moving to number 3. is this the Advent Health Winter Park Jorge, not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed.
Okay.
You want the exact pages? Because
Yes.
the BAC and the narrative,
That's what's going to be offered into evidence at this point in time.
then we'll work on that.
Appreciate it.
I've got staff here in the
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize, you're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them?
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense?
Judge, we have not yet received those records. We had Sarah doing sign on medical release, and we have sent requests to various medical facilities asking for records, and we're just waiting on response.
The objection sustained.
Why?
Moving to 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages
Oh no!
jail records regarding the Boone. Spend my personal
382
time
pages.
reviewing these records.
His personal time.
Poor thing.
Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through in the course of 4 years. The state just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates
Reserve
panic
going.
symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone.
Bitch.
The screening on 225 goes through
She likes people.
alcohol abuse, yes. Type, spirits, not wine. Last used,
Not wine.
320, several times a week.
She drank
Intake
spirits, not
screening also includes a
wine.
history of violence towards others, yes.
Pause.
So there's no,
Believe it or not, alcoholics can drink more than one type of alcohol.
Funny that.
Who would have guessed? But, you know, if you think that's some shade, like, oh, she was drinking wine that night, but her form said she was drinking spirits, like Grody. She's a liar.
He's just whining because he's got to look through some documents at the last minute.
And has to like organize photos and like flip them around, and they weren't in a PDF. Yeah.
How
He
annoying.
made my job hard. Well,
He really does come off like a dick. He does.
apparently
He does.
during the voir dire, when the defense was talking to the jury, asking them questions, introducing him, he would not stop objecting. Like non-stop objections today.
Oh, during voir dire.
Yeah, today. Yeah, this is like today was when they really started talking to the jury themselves, which is a very important time. But-
Yeah.
So he was, and Owens wasn't doing anything obscene that I saw, and he was just constantly objecting. But he got no objections that I saw from Owens. So
He's
it's
a
just,
bitch.
yeah,
He
and
is.
it's not a good look when you're objecting like that. It makes the jury sus.
Yeah, Brad, you're right. Sarah didn't take the deal, the good deal. It's personal. That's it.
You think?
He's Carrie Morrissey.
Yeah, I can
Yeah.
see that.
Yeah, he's totally got a Carrie complex now. Like, he's like, I'm gonna fry this bitch. That's what it's about now. And you can tell it from the way he words his motions. His motions are so full of shade. Oh, her latest version of events.
Well,
Yeah.
okay, when we get to that little spoken word thing that I was talking about, at the end of it, it's about. You remember when Owens first came on? He wanted a statement of particulars about what exactly the state's theory is, and this judge's like, they don't have to give that to you. Well, after he goes and does this whole thing about what their theory is, Owens makes this snarky remark like, "Oh well, it would have been nice to have that in writing a month ago when I asked."
Huh. Yeah, well, fair enough. Like, they've got the jump on him by 4 years. He just walked in.
Yeah.
Right? Like, they could cut him some slack, Owens. Like, they really could cut him some slack. They've kind of been a little bit Judge Go to him. Like, you're not welcome.
Sorry, Scott.
Yeah.
Well, you know. God damn it, you know. Anyways.
What? Yeah, exactly. Oh, what, are you spoiling things for us?
Apparently.
Apparently. All right, let's keep going.
Psychiatric treatment records for treatment for trauma, any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed. There's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that was pre-existing before the jail.
Yeah,
So
because Sarah wouldn't have
our
gotten
objection is
anxiety in
we
jail
don't
for
understand
4
the
years.
relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant. And it would bog the jury down, much like the 87 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results, and it's
Embarrassing.
we struggle to see the relevance, Judge.
It's embarrassing.
Oh, God. I'm going to really have to turn into Valley Girl for him.
We addressed
Yeah.
that yesterday. That's not germane to the
God.
issue.
As soon as I got to that word,
Oh, Jermaine's back.
he mentions anxiety was pre-existing. Now, that's
Is that the black attorney's name?
Warner opined in her deposition.
Henderson.
Anxiety she may have suffered from at the jail was from being in the jail. So there are questions about that, but generally you get these records as you
Yoo-hoo, court. Is there something you'd like to say to the rest of the class?
I can hear him.
What is the relevance of these
You
records?
turn on.
What do COVID tests have to do with anything in
No.
this case?
CC.
What do blood tests have to do with anything in this case? If they don't, then
Dali, if I turn on audio thing, everyone else is going to boom in our
No,
ears.
no, that's fine. I was closed caption.
Can't.
Not yet.
It's not
Okay.
available. No. Like, sometimes, like, they bring them up automatically, but I can't bring them up.
Sure.
So, yeah.
They're not big
Sorry,
enough.
I'm doing all I can.
They also.
Yeah.
what of these 382 records, 382 pages of records are relevant? What specifically is relevant? What page? What date? What document? You're not answering my question, counselor. They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
I don't intend on introducing these exhibits. I intend on potentially the doctors, the experts, Dr. Jorge, Dr. Harper, to rely on these.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If
Like it's more
she has not
work.
reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited cost for the
Oh
transcripts?
my God.
What relevance is it
Gag
to
me
her
with
if
a
she hasn't
spoon.
reviewed these records? They got these records post-deposition, post-evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. And then we took her deposition the 1st or 2nd. So this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce
Right, Scott?
evidence, because of course, experts can rely on inadmissible evidence if within the course of that area of expertise, it's the type of evidence that's routinely relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. The state didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront.
I need,
I'd like to know whether or not
there's new
their
issues,
experts
like I
have
need a
provided
tissue.
these new records so that we can address that.
Mr. Owens?
Judge, I don't want to go in. I'll wait. I will not have.
So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we will take on the deposition. So I'll wait. I'll
Okay. State with,
That was the only purpose.
okay. So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
Yes, sir.
All right.
Aw, Sarah has 2 cups of water.
Then based on counsel's representation, the court's not going to sustain or overrule the objection as the defense has identified they're not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11, there's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence in itself, but the reports may be used to refresh the officer's memory if needed during their testimony.
Okay. Does that cure that understanding?
Yes, sir.
Okay, all right. So based on Mr. Owens' representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence.
She does.
Moving to Exhibit 17. No, I'm sorry, 16. 16 is a repeat of 11, so the court's going to adopt its, or similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing?
Yes, sir.
Okay, so court's same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
No, Your Honor.
Response?
The defendant is not intending to introduce the jail form.
Okay, the objection is sustained. 18, prior criminal history of George Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously, we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about the prior interactions with the state attorney's office.
Okay. Response, Mr. Owens?
Judge, we're referring to the prior record involving Sarah, that Sarah's aware of.
Okay.
I know he had some priors in Pennsylvania, maybe Massachusetts, we're not referring to those. We're only referring to the ones involving incidents involving Sarah.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent, because you can't rebut it?
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion. Because if it's oral testimony, that may be a different critter once the overt act is established under Holland.
that that evidence being used to refresh the officer's testimony. The officer's testimony, we believe, is going to corroborate Sarah Boone's testimony without her injuries, photographs, the officer visibly observing injuries on her. That's the nature of this. So I don't think
Why are we just zoomed in on Sarah?
anything about prior criminal history other than what she's testified.
Yeah, can we?
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that we have to cooperate and ask the court to take some judicial notice that there was a case file that was set up to handle that criminal prosecution.
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant.
Hey, Melissa.
The disposition of the papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits, and that's what our objection would be to believing that what was represented was a criminal rap sheet.
Judge, part of battered spouse syndrome, and Dr. Brennan will testify, Dr. Harper will testify, Dr. Warren will testify, is this feeling by a victim of being battered that she has nowhere to turn. His family can't help her, she has no move. The state attorney dropped 3 of the charges. 3 separate times when Torres was arrested, charged with violence against Sarah Boone. At her request, she wanted them dropped. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had let her down. They could not, they dropped 3 of the cases, so she felt helpless that there was some outside entity that would protect her. That ties into her state of mind as to whether or not she felt an imminent threat at the time of this event. So that may become relevant depending on what Dr. Harper says, Dr. Warren says about that, what Dr. Brandon says about that, as to whether or not she felt helpless because the state attorney's office was not prosecuting her when she was the
But that all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the exhibits? Tangible, physical?
We may want to introduce something in a court record indicating that the state attorney dismissed the case.
Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list.
Well, I mean, I can see what it has to do with it. If she was in fear for her life for years leading up to the incident, then that prior criminal history could be relevant, right? Like, if the prior criminal history includes some charges that actually relate to his outbursts over a period of time, could that not relate to why she was in fear for her life? Could it not come into evidence at some point? Like, and he's, guys, if you can't hear properly, what Owens just said was that it could come into evidence based on what the experts say. So based on what Dr. Harper says, etc., etc. So there's 3 experts. And so he can't know whether or not these things are going to be coming into evidence or whether they're going to become relevant until those people testify. So he wants them allowed, potentially. I get why the state doesn't want them allowed, but there could be things in there that could become relevant. So it's tricky, but if you're just going to suppress it from the beginning, then what if he needs it? What if the defense needs it?
I'll withdraw the prior criminal history.
Okay, all right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right.
But is he, Marsha? is he talking about potential prior criminal history from before he met her MPA? So she would only know of it through hearsay since she wasn't there. She shouldn't be allowed that. Or hang on a minute. If he had a history of being violent with his wife prior, so causing her to feel fear for her life, is that not relevant? So is the defense trying to prove that the decedent was a dangerous person, so was someone who was an abuser, right? So, but do we know that? Is she going to be testifying? Right? So does the defense potentially have her to testify? In which case, he should be saying so. Like Owen should be saying that if that's the case. But if the defense had the ex-wife to testify, and there was a prior criminal history to go with that, then that would make more sense. But yeah. So what did the judge just decide? I missed it. Sorry, we'll go back.
Moving now to okay, all right, because that's the topic here. Physical.
We may want to introduce something in a court record indicating that the state attorney distanced.
Okay, what does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list.
I'll withdraw the prior criminal history.
Okay, all right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff.
Okay, so he withdrew it anyway. So it's just, it's irrelevant. He didn't try and bring it in the stuff from Philadelphia, but regardless, I mean, I guess I'm just trying to understand why it could potentially be relevant. These arguments are always interesting to me. I still believe George was reactionary and Sarah was the aggressor, since Brian said she hit him when she was drunk. Yep. I just don't think there's any way of knowing, Marsha, unless you were there, or unless there's people to testify to that. So we'll see. We'll see.
Office investigative workup report response.
This will be used to refresh the officer's memory if need be during their testimony.
Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay. So accepted. Your objection's overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong, I color-coded this and I miscolor-coded this one.
We don't introduce anything on 20.
Okay, then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because it's we kind of addressed this as well with number 19. Anything further, argument state.
Okay.
Anything further, argument?
No, sir.
Okay, I'm going to overrule the objection as to, as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence. Moving to 22, family law case file, Boone v. Boone, case number 2017 DR01.
I just remembered the next thing that we're putting up once we get to 20 more gifted memberships isn't the Pop-Tart. It's the hand coming out of the suitcase. When they said he said overt act, I remember that I promised David that the next thing was going to be the hand coming out of the suitcase, which is going to really piss people off who come in and don't know us. They're going to go, what is that? I love it. So yeah, that 20 more memberships, guys. We're gonna have the hands. Yes. And we'll have Pop-Tarts after that. But yeah, I want the hand. The hand coming out of the suitcase. Yes.
660-O. I understand the state's objection is to relevance and hearsay. Response?
It wasn't my idea, Marsha. It was David's. You can blame him.
For the defense, and he may be considered an adverse witness or a hostile witness, and so we may attempt to establish either bias on his part based on some of the documents or orders in the court record, or we may reflect, for impeachment purposes, the fact that he has not complied with some of the orders, and that the reason being is because of his feelings for the defendant. You know, he's now got full custody of their son, and has had full custody for 4.5 years. That was not the agreement he originally had, and he was ordered to pay out loan, which he has failed to do as a result of being incarcerated. So there's litigation going on. Ron Boone, that's counsel, Sarah Boone is not.
Okay.
What does
Based on what he says,
what does the non-payment of alimony have to do with what's happening in a family case?
well, that, Judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached, that her in the position that she's in now, he's biased. And to show that he's biased, that he has not paid alimony for it. He's supposed to pay $1,000 a month for a number of years, that he's just failed to comply with the court's order. That shows his personal bias or feelings towards it.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge of the Ninth Circuit Family Division. And I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. And it sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of the hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony, and I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into, under cross-examination.
But it sounds like there's pending litigation, including a relocation or, and I don't know because that's not my case and I haven't looked at it.
That's been decided. He hasn't been able to relocate. I don't know all the ramifications. I'll look at the court file. I think we had subpoenaed the custodian of the records of the court file. I'll look at it and I'll let the court know and the state know.
Can you all approach this for a moment?
I have to let the cat out. If I don't let the cat out, he's going to get really, really mad. Excuse. Okay. Back. No, I didn't have the cat in the bag. All right. Well, we will skip this waiting. Are they having a dance in the back? Waiting. Yeah, Shelby hasn't done that great of a job with the makeup. See, this kind of zooming in thing is why they actually took the, pool cameras away from Brian Koberger's case. And they made us, watch with potato cameras. Oh, look! Isn't this cute? Aww. All the girls together. Oh, Dolly, thank you. Thank you for the membership. Dolly gifted one excited utterance membership. Thank you so much. Now We have 19 to go till we get the hand. The hand. 19 to go. Thank you, Dali, for your support, my lovely co-host. Yes. I will leave it. I'll leave Shelby there. I know you boys want to see Shelby. Besides Shelby being a pageant girl, she can't risk Sarah outshining her. No. No, look, I think they really are getting along quite well. And Dali gifted another Excited Utterance membership. Now we have only 18 until we get to the hand. The hand.
Oh, look at those two.
I know, right?
They're so cute.
Oh, they're talking about bras.
So, my court reporter said that she had a ring on her finger. And I was pretty distraught. But Scott
Your
said,
court reporter?
yes, mine and only mine.
Yeah, yours, yeah.
No other one has access to this. No, but I
I
know
thank y'all
somebody
both for your
in court-
arguments and clarifications based on, the court's going to overrule the objection at this
Pause,
time.
pause.
Well, pause,
Bra-
pause.
Brandon. Oh, boy. She's
Brandon,
she's
haven't
not
you
an attorney.
looked? Haven't you looked? Look. Look at this chick.
Let's just say she won Bikini Coast International 2 years ago. I have video of her celebrating.
Yeah. She's Miss Pensacola, she's Miss Atlanta, she's Miss goddamn Bikini
No, she's
something
Miss
or other.
International. And she
Whoa.
worked at Hooters.
Well, of course she did. They all did. Yeah, she's pretty good looking. I mean, come on, look it
For a
up.
blonde, yeah.
Yeah. Yeah, it's a bit platinum, the old hair. And like
I
the
mean-
bum part, I'm not keen on the bum part.
Yeah, and she has
But-
had some work, but yeah.
Yeah, well, yeah. But I mean, come on. You're on your phone. Well, let's go. Just like fire it up and have a look. But yeah, anyway. Yeah, she's not bad. She's not bad.
Yeah.
Anyway, thank you, Dali, for the other gifted membership. We are now 18 away from the hand escaping the suitcase. She's had butt implants? I don't think so.
Probably.
Her butt's not that big. No, it's not that big. Yeah.
Oh,
She's
boy.
cute and she's nice to Sarah. She might even be smuggling Pop-Tarts. She could be smuggling Pop-Tarts, so I wouldn't put it past her. Nothing says classy like a tube topping court. Good point. Good point. Her lady blazer hides her wings well. Yes, I agree. I think you're talking about Sarah there. All right, let's keep going.
I thank y'all both for your arguments and clarifications based on, the court's going to overrule the objection at this time for the reasons discussed at sidebar. Moving now to 23.
Deal.
Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay, all right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay, based on counsel's representation of not seeking to utilize it, court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay, all right, thank you. Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
State, do you have such an item in your possession? News footage?
I've got it.
No? Not that I know of.
All right, but we have not received it, so we don't have the evidence.
Okay, all right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name, not going to read it, it's very long.
Judge, I do not intend to introduce
Crazy.
29.
Okay?
Guys, that stuff of her being arrested, that's in my Sarah Boone video, my music video. If you want to go watch it. By the way, if you want to watch it on repeat, it's in my video section. mods, if you want to chuck that in there, because I'm trying to get that one to go viral. I'm putting it a link to it in every pinned comment section at the moment, because I think during the trial it just might. I hope it does. It's a good song.
And the court takes no action based on counsel's representation. Moving to 32, iPhone photo. Yeah, I'm sorry, sir.
29, what is the ruling?
There is none, as the defense has advised they are not seeking to enter it into evidence. 32, another iPhone photo file name. It's very long, so I'm not going to read it.
Defense does not intend to introduce.
Phrasing.
As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG underscore embedded underscore 1 underscore 772.
We would stipulate.
The objection is sustained based on stipulation. Moving to 59 and 60. I understand your objection stayed. Any response?
Any or all exhibits previously listed by the state?
Yes, sir.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified. He's filed this motion in limine to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And so practically, he was able to get us to that posture, so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone, and state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault. But he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that. But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day. And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes to directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Yes, sir.
Here it comes.
Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion to eliminate. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games, it was Sunday fun day, he gets into the suitcase, we're all laughing, I zip it shut, we're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion and that if that is the proffered testimony, that that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence.
Oh, sorry, Laura.
They weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and
Maybe
Mr.
the
Cacciatore
fingers.
to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do, and we're making every effort to make sure that we understand how this trial is going to go down and how they, and Ms. Boone understands how the trial is going to go down, because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day, and right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony, unless there is. Then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12,
Oh, yeah.
45 p.m. on 2/23/2020. Sarah, for everything you've done to me.
Oh.
Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby, seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not, she let him remain for 2 minutes during that video.
So
And then at 11:23:03 p.m.,
weird.
there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, Jorge Torres, George Torres, died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that
Not the one I
suitcase
did.
when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit it with a bat, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony through all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
I I wanted that in writing weeks ago.
Boom!
Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's excerpt. The characterization that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Werner, 5 of us there. Dr. Werner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment. Because I can't testify to what she said. The 2 prosecutors can't testify to what she said. The only 2 people that can testify to what she said is Dr. Werner and Sarah Boone. We dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and then Dr. Werner. And the jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. It was something I was asking for
Eventually.
a couple of weeks ago.
Yeah, I said it again.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraph 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the cost of expedited transcripts. And I just want to make sure they meant to overrule that request.
I
Yes,
apologize
Pat.
because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents.
She looks
deputies
kinda like
that were
Jodi
went out
Arias
and
in the
call-outs
back.
Cases that resulted in cases in the state attorney's office and 911 dispatchers.
Okay. Is that accurate, Mr. Owens? That October 3 state's list?
I don't know.
We don't dispute that they should be allowed to depose them, but
She really looks like
they've been
Jodi
listed by both
Arias.
parties, whereas these
Who?
people are unilaterally.
The girl in the
listed
back.
by the defendant.
Judge, again, I'm not.
With the white thing on.
Been on the
No,
case
no,
for
no.
45 days. As
On the
we
left.
have gotten witnesses or found witnesses, Billy
Kind
Lane
of.
or whoever else was trying to locate them.
No.
on the team, we have,
A little bit, not much.
based on what Sarah Boone has asked
She's
us,
very pretty.
this witness,
Liar.
This witness, we've made attempts to comply with her request. Whether or not
Lucy
we're going to call
Liu.
them.
Yes, she looks like
The law
Lucy Liu.
says, the case law says, Sarah Boone has a right to trial, Sarah Boone has a right to testify, Sarah Boone has a right to appeal. I believe those are the 3 fundamentals. But the defense lawyer
Is it really?
makes the decision about which witnesses to call. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them, and it may not, we may not call many of those that she wants to, but I believe my right to do that and to present our defense with our witnesses is paramount, and she does not have the right.
Can you guys hear him
Thank
now?
you.
I can
All right, court's
hear
going to
him
take a
much
brief
better
recess
now.
to address this and the Richardson violations. We'll be in a short recess. Thank you.
This part, I think Owens is talking to Sarah, not the judge. What are you talking about? What, this next part?
No, I
Are we
think
gonna
that
hear
part where he's
Oh,
talking about
okay.
the witnesses to call or whatever.
Oh, right. Okay. So I'm just going to fast forward a bit, see if anything much else happened. Bloody, 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 bloody.
No, they had a ton of tech issues.
Yeah, okay. I don't think there's anything else. Oh, hang on. What's this? Let's just check.
All right, we're back on the record. Case number 2020 CF
Hey,
2603, State of Florida versus Sarah Boone. State appearances for the record.
William J.
Defense?
James Owens for Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from earlier this morning.
Why does he
All
keep
it
talking
is
about her clothing?
11:24. With regard to the Richardson
Notes that she's in civilian
hearing
attire.
with regard to item 6,
I've not seen that before. I've never heard of, like, watched so many trials, and to have the judge constantly reporting on what the defendant is wearing, that's new.
Could just be a picadillo of his.
Yeah.
in the defendant's Fifth Amended Reciprocal Discovery List,
Or
the court is going
identifier,
to
yeah.
reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was your right.
Okay? Did that happen when I was not here?
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 was the 119 new JPEG pages, according to from Winter Park Advent Health, and they're a little bit different than the one pages that previously received.
So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence. Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses.
Who
The
are
defense shall
they?
pay for any and all expedited transcripts.
All right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
Thank you.
Okay, response?
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that was unavailable during the trial period, so in an effort to not continue.
Oh, thanks, Donna.
Got a substitute analyst. So that's our reason for the late disclosure on her with the other 2.
Michelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts, what I would expect. Not like
Okay, now we
Okay.
can't hear Mr.
Has
J.
the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Castro does not believe that the defendant ever proposed.
Okay. Any other positions, Mr. Owens? Okay, all right. State will afford the same opportunity to the defense as provided by the state to the defense.
Hey, AJ.
Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have the thing again, please? If you all still have yesterday's
Why are we buffering?
sheets from jury selection, Madam Clerk has advised that jury services has told us that juror in seat 25, wearing badge 63, called. Is it Johnny? The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any.
For cause.
So stipulated, juror number 25, wearing badge 63, will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report.
I'm not quite sure
With
why we're
regard to the
buffering right now.
Orr-Tennis
Everything
motion,
was.
as to Ms.
everything's
Boone's
been
request
fine.
for snacks, the Orr-Tennis motion is denied. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at
No
1 p.m.?
snacks.
Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record.
Oh, look at her. She's like, but I'm. Oh no. Is she diabetic? Someone said she was diabetic.
I doubt it. She refuses breakfast every morning, so.
That's strange. Okay, yeah.
And if she got breakfast, she wouldn't need snacks.
That's true. It's a long day in court. I don't understand why you can't just, like, does she get morning tea and then lunch?
She gets lunch.
Just lunch.
I don't know if she gets, like, dinner, how that works. But lunch,
Yeah.
yes, she gets.
You would think she'd get lunch. You'd think she'd get, like, they get a morning break, don't they? Surely they would get morning
That too.
tea, afternoon tea, and lunch.
We don't really
You
do
would
tea
think.
here.
Don't you do? You don't do tea?
No, we're not British.
No, not tea. Like a break, like a morning
Well, yeah.
break, an afternoon break.
Sure, we have breaks, but
they give her 2 brown bag lunches. Okay, so
Yeah.
2 breaks, two food breaks. Okay, that's enough to get through the day. That's fair enough. Like it's just like, come on now, she's not been
Yeah.
found guilty yet. Like, feed her.
Yeah.
Coffee break, pee break, yeah. And then she'd get dinner in her cell. Yeah, fair enough. No, I get it. But, I mean, yeah, if I'm sitting in court all day, I wouldn't mind, like, some mints
Yeah.
or something. She's not been found guilty yet. I mean, come on.
Yeah.
Come on. It's not that bad. All right, so anyway, looks like we are on for tomorrow. Finally.
Yes.
Finally, please. Okay, that is cool. So what we're going to do is this. Whoop, whoop, whoop. Alrighty. We're going to share this tab instead. Hey, let this thing start, please. Yeah, let this thing start, please. That's what we're calling it today. Let this thing start, please. I think this was this. I've been following this case for 2+ years. Crazy, this thing is tomorrow. It's not really that crazy. It's been going on that long.
Well, that is finally here.
Well, yeah. Today, like this morning, it sounded like they were actually this afternoon, it sounded like it was going to not be till Monday
Yeah.
for a bit. Yeah, game time. Yeah, why not? We've waited through so much stuff. We might as well do games every day. Why not? Like, it's only a couple of questions, and it's been pretty hard to endure all this stuff. So why not enjoy? And are you typing? Is it you that's typing?
No?
What is that typing sound?
I don't know.
It was you.
It was.
God.
Ah.
Da, 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 da,
Suffadol. Suffahella.
Everyone get ready. Alrighty, everyone get ready. Owens wants to bring in evidence of the family court litigation to show Brian Boone is what? 1, big, 2, biased, 3, beautiful, or 4, based.
Or a deadbeat
Owen.
dad.
Owen wants to bring in evidence of the family court litigation to show Brian Boone is what? 1, big, 2, biased, 3, beautiful, or 4, based. Put your answers in chat. Ah, dear. I think he's pretty based. Yeah, he does seem pretty based.
He has put
I
up with a
reckon
lot.
He has. And he's pretty big also.
Is he?
He's a big dude.
Well, I've
You've
never seen him naked, so.
Oh, right. He's got a big bank balance. I know that. All right, Scott comes in first, and then Online Red, then Marsha, then Maddie, and sorry, Deanna. He's a beautiful man. He is a beautiful man. Definitely 5 beta. Beta.
Beta, baby.
Yep. So J-Rock's not here today because he got the shits yesterday because he said that it was rigged. But I'm pretty sure that Beautiful Waterfall and him just had, like, they were saying at the same time. So, how many JPEGs were provided this morning? 1, 81, 2, 190, 3, 119, or 4, 118? Whoa, is that a toughie? How many JPEGs were provided this morning? 1, 81, 2, 190, 3, 119, or 4, 118?
69.
How many JPEGs? How many JPEGs? Da, da. Hey, Masha! And then Scott, and then all unread, then Maddie. Sorry, Kat. Sorry, Lee, and sorry, Donna.
Almost.
Oh, well. Almost. Almost. But good paying attention, Masha and Scott and online, etc. 119, like they said it quite a lot of times, but then there was 81, it was exhibit 81 or something, or there was 81 pages. There was 81 pages. That's right. So I like confusing it with other numbers that are said. Owens wants to renew his motion for what? 1. Statement of particulars. 2. More lemonade. 3. Battered spouse defense. Or 4. Sarah's hair and makeup. Owens wants to renew his motion for 1. Statement of particulars. 2. More lemonade. 3. Battered spouse defense. Or 4. Sarah's hair and makeup. Put your numbers in chat. Put your numbers in chat. 1, 2, 3, or 4.
In the land of Amen, where kangaroos roam, there's a lady named Hannah with a heart of gold. She's a horse exception, excited utterance in her name, whispering secrets, lighting up the flame.
Who's gonna get it? Hey, Masha again! Oh, Masha's heading for the win. She's heading for the win. Sorry, Lee, not more lemonade. Beautiful, and all in red, and Maddie. Oh, I thought some people might have gone for the battered spouse defense. Ah, well, you're good listeners.
Yeah,
You're
not
good
bad.
listeners. Not bad. Dahlia, you playing?
No, not right now. I didn't want to cheat.
Didn't want to cheat? Why would you be cheating?
I know all the answers, so it wouldn't be fair.
How would you know the answers? Oh, you think you're so good.
I do.
Mr. J said, if Sarah changes her story again, it will be a whole different what? 1. Jar of snakes. 2. Can of worms. 3. Bag of worms. 4. Bag of dicks. Mr. J said, if Sarah changes her story again, it will be a whole different 1. Jar of snakes. 2. Can of worms. 3. Bag of worms. 4. Bag of dicks. Yeah, it's a bit of a tricky one. What did he say? Now, I'll tell you something interesting. Dahlia was once sent a bag of dicks.
I was. They're quite
He was.
tasty.
Yeah, he ate them too. He ate a
Only
bag
a
of
few.
dicks.
I didn't eat the
You
whole
ate
bag.
You ate the whole bag of dicks.
I did not enjoy the whole bag.
Do you want to know who sent the bag of dicks?
Stupid asshole.
David. Bag of worms! He said bag of worms. Right? Replay it. Oh my god, he said bag of worms. What a stupid thing to say. He did not say can of worms. He said bag of worms. He has bags on his mind. Well done, Masha and Scott. Sorry, everybody else. Maddie, beautiful, Bob, etc. And Kat. Kat. He didn't have Kat. Yeah. Well done, Kat. Yep, gotcha. Gotcha on that one. Oh,
Yep.
well, yeah, he did. He said bag of worms.
Yeah.
I know, right? Game on. Ah, this is the observation 1. Sarah's legal assistant with the dark hair had what kind of laptop? 1. E-machines. 2. Mac. 3. Lenovo. Or 4. Asus. Sarah's legal assistant with the dark hair had what kind of laptop? 1. E-machines. 2. Mac. 3. Lenovo. 4. Asus.
Asus.
Oh. I think we say Asus, don't we?
Oh, I don't know. That's how I say it, but
Were we paying attention? Were we paying attention? Ha 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 ha. Ha 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 ha. Yay, Maddie B and Beautiful and Bob and Online Red and Half Irish and AG. Sorry, Scott and Marsha. Oh, look, Scott and Marsha. Oh, look at that. And I'm bronze. Well, I'm bronze. You came in late. But Scott and Marsha, I love it when it upsets the apple cart, doesn't it? Every time. Every time. Oh, damn. Damn. Look very Lenovo. Well, yeah, that Apple logo really looked very Lenovo. Sure did. You demand a recount. Oh, Marsha still won. Scott Wade still won. Look at that. Look at that. Well, you got so many right that you still won. And Maddie B third. And then Outline Red, then Beautiful Waterfall, then Half Irish, then AG, then Bob, then Brad, then Barbara, then Bronze, then Kat Madison, then Lee B, then Donna Barkley, then Deanna. Well done, everybody. You guys should be pretty pleased with yourself. You still haven't won yet? Scott beat you again? Nice, Marsha. Donna, you don't suck at it. You just need more practice. You didn't even watch the stream. Well, you can guess. It's just you got to be really fast at it. That's all. Well done. Nice, guys. Nice, guys. Marsha, I know you've been trying really hard to get this win. So I've got to say, nicely done. And you've stuck around. You've been paying attention. And I know those last questions have been getting to you. So... nice. You're on lag today. Weird how that happens. Yeah, it's strange, hey. Nicely done. Nicely done. You won. That's right. You did win once, and it's been downhill since. Well, you've won a year's supply of a bag of ticks. Dali can supply those. Like, you know which ones are good.
That's true. That's
right. All week, Scott Wade, unfair. Has Scott won one? Have you won one, Scott?
Yeah.
Sure. Yeah. I need to make a leaderboard of the actual winners and put them. I need to show you where I'm going to put them. I'm going to put them. If I just remove that, see, I'm going to put them there, like in the back of the suitcase. So when we remove the screen, you can see the winners on a panel there. That's a good place to put it, right? Hello.
I was muted. Whoops.
You just muted yourself. Yeah. So if I put it, if I take that away and put it there, I could put it there. That would make sense, right? Yeah, Wall of Fame. Yeah, that makes sense. Yeah, cool. You're good with 4. You can retire. No, you're not retiring. You need to make it to 6 or 7 because that is Half Irish's record. She's got the record, right? So no, you need to keep going. You definitely need to keep going. Alrighty, so, Dali, are you streaming tomorrow?
No stream tomorrow, unless something breaks, but probably not, so.
No? Okay, alright.
Just help out with Sarah.
We are definitely streaming tomorrow, and we are doing the whole trial. Let's go, guys. So, if you manage to catch any during the day, that's great, but I'm not too fussed about spoilers, but, guys... make sure you're here, 6 p.m. Eastern. We're going to run it on fast speed. No breaks, no nothing, and then games. I will be asleep for the daytime stuff, just like you are sleepy right now, Dali. And we hopefully will have David here as well, have a lawyer on board. And yeah, it'll be my Saturday. I can't wait. I'm so excited. And we are 18 away, is it? We're 18 away from our next, we got a dog, etc. We're 18 away from our next milestone, which will be the hand creeping out of the suitcase. Thank you for the gifted memberships, everybody. I can't redirect to Andrea. She does not have her privileges on. So that's cool. And I don't think she really needs our redirect. She's got probably 2,000 people in there. But let's go over to Andrea anyway. So I will be over modding in Andrea's chat. Everybody, let's go over it and support Andrea. Also, have a little look at my little video that I made. Give it some likes and stuff. Do we have that ready to go? Let me see. Let me see if I got my video. My video. I think that Judge Gull might not be real. I think she might not be a human being. It's quite possible that she's not real. Let's just put that out there. She doesn't need sustenance. So, yeah, there is that. There we go. Is Gull real? Go have a look at that. Put a little like on it. Maybe a comment to get it going in the algorithm, guys. I appreciate it. Much appreciated. Thank you very much. And yeah, let's go and support Miss Andrea, who's doing a fantastic job in Indiana, away from her husband and the rest of her life for 6 weeks, risking everything to be in the presence of Judge Gull. Boom, boom.
Evil.
She's scary. She's really scary. She sounds super scary.
I know.
Everyone in the courtroom sounds really scared of her.
Reminds me of my ex. And Brock, his first wife.
Yeah. Yeah, cool. All right, I'll see you guys tomorrow, 6 p.m. Eastern. Don't miss it. Love you all. Thanks for being here. And time for the song.
Her name was Helen. She was an Aussie. She was a fake lawyer from the future. She got on YouTube and made some live streams. The co-host is Donnie and she dances sometimes. The words are always so loud and because she's an 803. To be excited, you're